Yes, welcome back to the No State Project here for September. Wow, November. It takes one tech issue to just knock everything out. Yes, one of those guys. We had another tech issue. Don't think it was on my side, but welcome to the No State Project. We'll give this a shot again as long as we got audio, and you guys will let me know either way if we do not have the audio just yet. Once people start piling in, so can you just give me an all clear that we've got actual audio this time, and we don't have another? I believe it was on the. I tested everything. I always test an hour or two before, and I test immediately before the show, and then I start the show, and as usual, I did 4 or 5 weeks without shows without an actual tech issue, so it wasn't too shabby there. But hey, it's December 14, 2019. I'm glad to be with you here in a fortified compound. And what I mentioned before, when nobody could hear what the hell I was saying, maybe some people prefer it that way. In that we call it I call it a fortified compound because when the mainstream media to go with those government types, when anybody challenges them and questions and doesn't accept what they're handing out without a critical analysis and critical eye, if you dare challenge the legitimacy of government, and you do so effectively, to where you've got people in government arguing they don't have to actually prove that their claim is true, they tend to frown on that, and so they got to make it sound like we're scary people. We don't live in houses. No, we live in compounds. It's just got that, that air. Ooh, he lives in a compound. What kind of person lives in a compound? Well, the Kennedys did. They were, most people who are wealthy live in a compound. To have a compound, but even if you just have an unattached garage, if you've got two or more structures on your property, you're in a compound. They didn't live in a basement. No, they had an underground bunker. Ay vey. So that's why I say that. But welcome to the show. We do appreciate everyone supporting the show. If you would like to do that, markstevens.sales.com. And my website, of course, markstevens.net. And I'm going to talk a lot about court procedure again today, especially because of what's in that there news. And it's funny how some of these people, who are behind some of the most unethical and immoral proceedings are crying about things being unfair. And that's now going to be on both sides there. But if you want to join me, the number is 218-632-9399. 218-632-9399. The passcode is 2020 with the #. And instant message me first. Yes, definitely instant message me. Don't just call the show. I mean, like I said, we'd like to have some little bit of professionalism, and but I think Nelson here. No, we're on. We're on. We're on. I meant one. Well, I can't type and talk so well at the same time. But yes, 218-632-9399, 218-632-9399, and the passcode is 2020. And Skype, of course, you can instant message me first. And yes, you can always. I don't always look at the chat here on the comments on YouTube, but I do, and I did put the call number into the show notes already. So hey, yeah. So I guess remembering that kind of gets canceled out by the fact that because I had a tech issue and I had to start the beginning of that there show again. But let's get right into this here because, well, actually, we're going to get to the calls because I know some people get really irritated with that if I don't take calls immediately. And I know they've been trying to get back on the show for a while now. But we've got Linda in Oklahoma. Welcome back to the show.
Hello, sir. Glad to be back.
I'm sorry, something got hit. Welcome. I didn't hear what you said, but welcome back to the show, Linda.
I just said thank you, sir. I'm very happy to be back. So many questions, but I think my first one, unless you have advice already, because I know we have been speaking over the email. I need a game plan. I still am without an attorney right now. I have a court order from the judge saying I have to get an attorney. So I've been looking at, and I want you to reprimand me, I have been looking at Color of Law, the COL form. What do you think about that?
The Color of Law Forum? Is that what you said?
Yes, there's a form. It's called a COL. People are saying it stops these folks in their tracks. You file. So I'm all for that. I want some tracks stopped immediately.
It doesn't work that way. There is no magic words that every case will be thrown out and stop it dead in its tracks. You can even show that you're the wrong person that's been charged. That doesn't even necessarily stop them dead in their tracks every time. In fact, I've seen, especially in these traffic courts, they don't give a damn. They don't. I was there in the Mesa, one of the Mesa Justice Courts. The guy had documentation, verifiable proof, evidence, solid evidence as it gets. He was not the one in the car that was a photo radar. He could prove he wasn't in the car. He was out of state. He was not even in Arizona. Judge didn't give a damn. Didn't accept it as proof. It's just like there was somebody falsely convicted of murder a while back in New York. The guy had video evidence, had testimony from eyewitnesses. He was in Florida at the time of the murder. Couldn't possibly have been him. They still convicted him.
That is frightening. That's beyond frightening.
Yeah, these things really happen. It's horrific. So anybody telling you, see, there's something you notice. You look at someone like, gosh, I'm drawing a blank on his name, Jerry Spence, a guy who is a lawyer who teaches, I guess he teaches law, and he has never lost a criminal case. I don't remember him ever putting anything. Now, he's got a track record here, right, Linda? This is a guy who has a track record, an undeniable track record, the only undefeated criminal attorney, period. He's the guy. And I have never had anyone say to me, well, yeah, you go and you do what Jerry Spence says, and he says it'll stop them dead in their tracks. It doesn't, someone's lying. Color of Law Forum?
Yeah, it's a COL. It's a one-page form. You serve it to whoever has, accused you or whoever you think is in violation. Let's see, let me get the words right. You sue they have violated your rights under color of law. It applies only to people working in that capacity, such as the police officers. If, like in my case, they walk up to my car and they think they see a mark of some sort, they want to get me, they're just going to ignore my rights and proceed to come get me, break in my car and break glass in my eyes and all the rest of that. They have abused, I guess it's kind of like abusing their badge or whatever, their place in the government. I need to do more research on this, but
no, you don't.
It goes along.
What I would do is I would wait. Lynn, I would wait until I was out of jeopardy. If you're going to look into these things and spend time doing that, which I think is a complete waste of time, but hey, check it out, see if it has merit. It sounds ridiculous to me. I think anything that sounds like a silver bullet that says do this and I'll stop them dead in their tracks. There is absolutely no such defense. Again, anyone doubts, just go look up all these things that were the abuse that police officers have engaged in, and it doesn't stop the underlying prosecution. So, like I mentioned to you in an email, there are cops that have been, beating the crap out of somebody, and they, just like they're doing to you, they charge them. Because they bled on their uniform. But it was your fist. It was your baton that caused the blood to leave my... It is so...
Yeah, exactly. It's insane. It's insane. You should have seen this guy look at his sleeve as if I had just poured AIDS acid on him. He caused all this. He pulled me out, pulled me to him chest to chest, which just didn't make any sense. I think he wanted me to spit on him. I don't know. I don't get it. But I need to find something. I need to find the defects. Am I really supposed to be at their mercy? Get a public defender who is not defending me? His fiduciary relationship lies with the state, and I know this. How can I walk in the lion's den like that?
Well, their first obligation is to the court, but it's supposed to be, if you go by the actual ethics rules and the actual rules of court, it's to aid in the administration of justice. And they do have, a second, another obligation that is supposed to be to their client. Lawyers have an ethical responsibility and a legal responsibility to zealously defend the rights of their clients to ensure that they get a fair hearing. Their lawyers have no obligation whatsoever that I'm aware of to, same as prosecutors. No, they have an obligation to administer justice and to ensure that they have a defense that is based on facts, that is based on law, that is logical and is reasonable, and not to necessarily get the case thrown out. If justice requires it to be thrown out, then that's then sure. But their obligation is to ensure that you get a fair hearing. Unfortunately, the prosecutor or the public defender may not see eye to eye in that the foundational legal claim of the prosecution that goes to personal and subject matter jurisdiction may not agree that that should be challenged, and that to challenge that is necessary in order to effectively defend you or somebody else, and to ensure that the hearing against you is fair. Because would anybody doubt that if irrelevant information was brought in and used against you, that would be part of a fair trial? I mean, obviously that doesn't sound fair to you, right? If irrelevant information was used. So relevancy is a very key issue. Yes, it's a low threshold, but it is a threshold. It is a burden that has to be met by anybody in court, as far as I know, and at least when the rules are being applied evenly. And so I don't think it's fair to allow the prosecution to make a foundational legal claim against me, and I can't have an opportunity to prove that, and he doesn't have to, and I can't question any of the witnesses that are actually making those arguments or claims in court. I don't think you can necessarily get. I don't think you're going to get a public defender who's going to see that challenging the foundational claim is necessary to ensure that your right to due process and a fair trial is actually adhered to. So if you are in a situation where you're forced to do that, like I mentioned, at least try to find or get that if they're going to force the lawyer on you, that they're standby counsel, so that you can both offer argument. For those who are in California, you don't have this option. They don't like what's called a hybrid representation, where even though the Constitution literally says that you can defend yourself and with advice of counsel, that you can defend yourself with a lawyer, not just that the lawyer is the only mouthpiece. But you're not there, so you don't have to worry about that. So standby, if they're going to force them on you, then at least see if it can be standby, so that you can both argue and make arguments and make objections.
It worries me that the word client legally probably also means you pay for them. You're not considered a client. I don't know. It gets really twisty. Agency disclosure and agency law. I think lawyers ought to be held to that, as us realtors were. Well, you can't get away with, much. As a realtor, you just really can't get away.
The thing is, I think the public defender, you are their client, and they are charged with representing your, making sure that your rights are not violated, that you do get a fair hearing. Just because I don't like the restrictive use or defining of the word client. Lawyers have a vested economic interest in putting forth this false claim that only lawyers have clients. I mean, it's stupid. You could say that lawyers have customers. because they are. Are they going to lose their minds? Right. No, they're client. There are situations where words, your precision in the words is absolutely necessary. I get that. I don't think that with the word client and customer, I think that's I think that's it's stupid. That's why people, they say, "Oh, you can't use the word client. You're not a lawyer." Okay, they're customers. Does that make you feel any better? Is your precious little ego, is it better for you if I say customer? There are more, but see, unless you
Heidi Fleiss also called them clients, so let's not forget that.
Okay,
I think they're all in the same business. Some of them. This is a dirty, crooked little county, though, and it scares me really bad. You would think that things would be of a status quo of some sort. Everyone, let's play by the rules or let's not have any. These people don't have any.
Well, that's not just Oklahoma, though, Linda. That's not just Oklahoma. Pardon? I mean, that's all over the place. That's all over. I had a judge, Hernandez, here in Mesa. And he was hanging his hat on that jurisdiction with the evidence of jurisdiction was in the complaint. And when challenged on this, because the cop was sitting right there, the one who wrote the ticket, the one who's legally responsible for those claims to prove them beyond a reasonable doubt, because there was no prosecutor. He was the prosecutor. When I questioned on that, what evidence, because we get out the judge, I know that the critics are going to be like, well, that's not the claim they're making. Judge Hernandez, like so many other ones, that personal and subject matter jurisdiction is based on their claim that if I'm physically in Arizona, the laws apply. That's what the man, confirmed. They all do, regardless of what some people say on the internet, right? So then when I backed him into a corner by what facts are on the record that proved that that's true, he admitted, the complaint really isn't evidence of anything. Thank you. And I said, well, if the complaint isn't evidence of anything, and that's what you just said was what jurisdiction hinged on, since there is no evidence in jurisdiction by your own admission, shouldn't this be tossed out? And he just, I'm going to deny your motion. They don't care. Yeah. So it happens in Mesa. It happens all over the place. The only reason why we do win is because, as corrupt as these people are, the majority of them still they think that they're the good guys and want to make it look good. So they stick to the rules somewhat. Now you're going to have your Dick Nobles of the world where none of the rules apply to you. Okay. Well, actually, I should say none of the rules apply to the prosecutor as long as the prosecutor is making you look bad. So anything that gets in the way of the prosecutor making their case. So that's why you get these ridiculous objections where you ask, what facts did you rely on to support your claim that just because I'm physically in Oklahoma, that your constitutional laws apply? And they object on grounds that it calls for a legal conclusion, where all you do is ask for the facts. So the rules, and the judge, that's a great objection. And the judge grants it. This is why you'll have the judge, literally, he's impeaching the competency and credibility of the witness to make legal determinations, which is what they do every day, and they take the testimony anyway. Due process requires, if the witness isn't qualified to testify to the matter, then they have to throw it out, but they don't. But if you try to do that
scares me. And now that brings up something I think I remember reading about courts of record. Facts can only be heard in a court of record. Maybe that's why they throw it out so much, is that we're not really standing in a court of record at the time. That part confused me. I'd like to go find that paper again.
Well, we've had things tossed out. Most of the stuff that I've helped people get things tossed out, the majority of them have been in courts not of record. They've been your little rinky-dink town or county justice court, the lowest rung, the police court. So it doesn't matter.
That's where I'm at.
I've seen in my experience that at least like say at the federal level, I have seen that the federal court appellate courts are absolute when it comes to taxes. They absolutely will not apply the rules. They will lie and lie and lie and lie again. And then they'll put out a decision that lawyers can then try to use against you. It's like, I can actually prove that in some of the cases they didn't even rule on the issues we raised. I can even show you where they won't even, like in California, they won't even get the issue correct. And that's why you see, like, the critics, they all tend, there's only a few of them. I'm not like somebody's where I've got legions of critics. I don't. And that's not because I have just because I have a small show. But gosh, I lost my. Well, in California, for example,
record rinky dink.
Yeah, well, they won't even. Well, they won't even get your like the critics will say, well, you're arguing that the law doesn't apply, and I have to correct them. That's the point I was making, and that's called a straw man, because I don't argue that. I argue that they can't meet their burden of proving their claim the laws apply by their own admission. And that's why there was someone, a lawyer the other day I spoke to, who was a county attorney, and she was saying, well, you can file an appeal. You can do that. You can pay on the protest, and then you can bring it. Yeah, I know. What I'm doing is I'm taking your statements down. I'm recording your statements, and I'm going to use them as the basis for the claim for damages. You are not.
Exactly.
So I said, Mr. Randy.
Yeah, you have to find the defects in order to have an appeal. So everything they say can be held right against them too.
Well,
if it is in fact a defect.
Well, you want to be able to show, like, see, we would be going in as the plaintiff here in a tax situation where the money is extorted on the protest, of course, and then a claim for damages is brought if they refuse to give the money back. So we can't be like them. We're not going to get away with making conclusory statements and get a presumption of correctness that is ironclad. That's for them, even though it conflicts with their law.
Right.
We are honest. We can't do that, because even if we are trying to be more like them and be dishonest, they're not going to extend that courtesy to us. And I'm not even asking that they do. So we have to make sure.
They're the only ones that have. Yeah, they're the only ones that can have presumption of any of that. We're not supposed to.
Yeah, so we are making sure.
It's insane.
Well, like I said to this lawyer, again, this is an elected county attorney. I'm not talking to some lawyer on the internet. I'm talking to someone who's actually now involved in the case, because the whole thing was the treasurer's office referred me. She knew I was calling because they had said, look, you need to take care of this for us, because she is counsel for the treasurer. And I had to let her know, we're not like you. I don't make conclusory statements. I do not make a legal claim unless I have the facts to back it up. And that's what I'm doing right now. I said, I wish you would answer a few more questions, but I get that you don't want to talk to me anymore. I said, but I've already got sufficient facts to use against you and the county. You're refusing, such as refusing to answer questions and come to a resolution without the matter having to escalate. So, the clean hands doctrine is a legal thing that I think most of us would agree to. You're supposed to do what you can in good faith to resolve the controversy. See, court is supposed to be a drastic last resort. Try telling the police or telling prosecute or tax agents that, but they don't listen. But I guess to get back, I think we're getting a bit down the road here. I think as far as it's all fascinating. It's all fascinating to me, and I like the word reclusatory because I'm going to use that. So thank you for that. I like new words. Something you need to point me to something on your website, custom tailored for me to go look at right now. Well, I think what's important for you is to learn the basics. That the burden of proof is on them. We don't want to make affirmative statements unless it's to point out that the record is not sufficient, that they don't have sufficient facts. But you've got a problem in that you have an order from the judge. You have to get a lawyer. And if that lawyer, if you're ordered to get a lawyer and you have to object that I don't think this is fair. And if they're going to go ahead and do it anyway, but you have to still make your objection so you can get it reviewed on appeal. because you may have to, if you lose,
Okay.
you may have to argue ineffective counsel.
How can I do the objection now after she's already handed me the pink copy of the order?
You can just say it when you're in court next time, or you can just write a written objection. I object to the order, and just so it's a formal objection on the record.
Okay, I'd love to do that in writing. Do I file it at the courthouse?
Well, yeah, I would file it with the clerk of the court and send a copy to the prosecution. And I'm formally objecting to the order. I guess you could also do it as a motion to reverse that. It's probably not going to get anywhere, but you need to at least have an objection on the record so you can have that reviewed, that you were forced to get a lawyer, and then through just for sake of argument, what could happen, that you're arguing that you were denied due process because you were forced to have a lawyer who is not going to collaterally attack the foundation, some of the most important elements of the prosecution's case, and that it was a foregone conclusion that you were going to be convicted because the prosecution was given a free pass. So you're arguing ineffective counsel. And so that's if it goes that way. Okay. Now, if they're standby, then it's not all on the lawyer's shoulders, that you would have the opportunity to give argument and to make objections and cross-examine the witnesses. So I would be prepping and doing role play and learn the basics here, like the Socratic method. How do you destroy somebody's argument? What do you go through? So I do these on consults, and I do it on the show. You first have to find out what the argument is. You want to know exactly what the position is. Now you see, and even doing that, and even if I have the exact argument down from the county attorney or the IRS or the a chief justice of the Supreme Court, even when we have the exact argument there's always going to be somebody on the internet that's going to say, nope, that's not true. And you got to take it with a grain of salt. What's important here for you and me and anyone going through this, it doesn't matter what someone says on YouTube. It doesn't matter if they're lawyers. It doesn't matter if they're court reporters. What matters is what are the arguments or the claims that are being, and allegations that are being made against you or that are being made against me. What am I going to do? I'm going to sit there and say, there's a court reporter on the internet, and they're saying that you are not making a foundation, that what you think is a foundational claim, it really is not. You are wrong, and you shouldn't be arguing that. You should be. That's ridiculous. It matters what the accusations are and the evidence to back them up against you in this particular case. Nothing else, So the prosecutor could be making the wildest claim that everyone in the world is saying, "Oh my gosh, that's wrong." Doesn't matter. Right. It doesn't. What matters is what you're able to show, and if you're able to convince that judge. Because I had a judge turn.
I told you. I'm sorry. Well, I did tell you what the charges were after all was said and done, right?
Yeah. But I don't know if you did it on the air. So why don't you just let everybody know?
I don't think I did. Yeah, they broke in my car on a traffic stop, broke in the back seat, groped at my seatbelt, which to me was my chest. So I pushed the officer's hand away from my chest by just a knee-jerk reaction. And he wrote me up for assault and battery on a police officer. They offered me 5 years straight time, not deferred, not suspended, straight time as my first offer in this county. These people scare me. I have never, ever been in jail, ever. Never been charged with anything, never been in jail. That was going to be my first ticket, actually. So, yeah, I need to find, forgive me if I'm looking for that magic silver bullet to go in there and go, pew, pew, you're done. Because that's really what I want to do.
You can't get that.
I need to,
There is no such thing.
I need the basics. That makes me feel warm and fuzzy right now, though, Mark. Is just everything you've just said in this last 10 minutes here. the claims and the evidence. Now, what evidence would they possibly have that I did assault and battery on a police officer? If his body cam was going, it just showed him breaking in my car and attacking me in my seat. It's still strapped in my seatbelt. Well, I don't understand this world anymore. I want to get off.
The evidence they're going to have is going to be your blood on their uniforms, and it's going to be the testimony of their fellow cops. Testimony is evidence. Now, it's your job, or you and a public defender's job, to show that that's not true, and that's why discovery is going to include the body cams. You need the body cam footage. You need the dash cam footage. If now, if any of that, I'm going to go out on a limb here. I know I'm going to predict here. If they have body cam footage and it exonerates you, you will not get it. That's the way it works.
Okay, well, this is what scares me. My attorney's already seen the body cam video, and he seems to just, I don't know, he's not talking to me. The 2 times I did meet him, I was like, okay, what's the game plan? And he just looked at me like I had 2 heads. Like, well, you don't get to know that because we want to send you to prison for 5 years. You old lady who's sitting in her car. How dare you? How dare you drive down the street in our town?
Well, I don't think a public defender or a lawyer that's supposed to be defending you actually said all that.
No, they're not doing anything. I said, well, what are we going to do against them? He just looks at me. No game plan. I'm very confused.
Wait, I got it.
Supposed to not.
This is something that I've heard from other people where they work in an office and some of them are pissed off and they could be friends for years. And they say, hey, hello, good morning. And they look at them and just walk away. And I maybe it's just me. I have a real problem. I mean, it's one thing if I'm questioning somebody on the phone and I ask my knockout question. I keep my mouth shut. It's like one of those sales things. The first one to talk loses. And I can sit there as long as is necessary for, and to make it as uncomfortable as possible. And if they say something other than what I want to hear, I will go right back. Well, I'll ask the question again. If I'm in person and I say something to somebody and they literally say no and just turn and walk away, I just can't let that go. I have to say something. Yeah. I like, dude, I'm right in front of you.
I'm like that too.
I am right in front of you. What the? But the thing is, it very few times has that ever happened where they just, I guess maybe I just have that face where people just can't stop talking and, and make, either by calling me a faggot or something, something equally bad. But if you're sitting there talking to your lawyer and you're asking him about the footage and you want to see the footage and he says nothing, you've got to say, excuse me, I know enough about this that you have an obligation to zealously represent me within the law and to ensure that my rights are protected. How am I going to get a fair trial if you're not going to tell me what is on the dash cam? So there's dash cam footage. Well,
when you're in chains and in orange and scared to death, you just don't want to piss off an already insane clown posse. These people, they're not normal here. Honestly, when this is over with, I don't know if I'll go back to California, but I need to get away from here.
Yeah, that's for sure.
It's very much like that. I was brought up in a professional family where, it was hammered in me. You look people in the eye. You enunciate, you always, make them feel comfortable by, saying something back to them. I think that's probably the empathy chip in most people where you would never leave someone hanging like that. It's a joke where they go, high five, then they leave you hanging, bro. It's not good. It doesn't feel good. And it doesn't feel good when someone doesn't look at you like an intelligent human being because you're dressed in orange and your hair is standing straight up and you have shackles around your legs. The whole thing is just humiliating to begin with, but you realize that they are treating you like what they think you are just because they're dressing you like that. And treating you like that. It's very, very frightening here. It's not like anywhere I've been. I've worked at 2 sheriff's departments before in California, in warrants and records. not in the field, but I drank with those guys. I went to the bar that all the, officers went to and joked and laughed and carried on. They work hard and they play hard. I had a lot of respect for these people. I don't anymore. The world's upside down. The world's upside down. They broke in my car, sent me to the ER, put me in jail for 4 months. And now the attorneys in the courts are acting like they've got to put me away. And I found out that Oklahoma, and I think Arkansas also next door to us here, puts women away 6-1 compared to any other state. I want to say the word misogyny, but, I'll avoid going there, with all this MGTOW stuff and what have you. But nothing about this seems correct. They had the mind virus.
I've got to move on to some other calls, but I want to make sure because before you go,
I could talk to you all day. Yes.
Instead of just me talking and you just, looking at me through it and not saying anything. I don't get how people do that. It's so rude. I mean, at the least anyway. So, all right, there's a little more context and I understand better why he's not giving you the time of day. However, if a lawyer that was at least representing you at the time, if they've seen the dash cam, then they've shared that information with the defense already. So you should be able, it should be a part, whichever lawyer that is should have copies of that so that if another public defender is assigned, they should be giving that to them and you should be able to see it.
Yeah, there's only 2 public defenders in this court system. So it's either him or the one that sends all the women up for 5 years minimum. There's a gal in there for having a dirty house, and the CPS came, and anyway, they offered her 25 years the first time and 30 the second time. I have a call into the governor and a complaint form I need to fill out for the attorney general. When I say there's something really wrong here, I mean it. I don't know. They're all on dope. I don't know. I can't explain it. It's not of normal intelligence.
Well, they're definitely drunk on power, I would say. I would say they're drunk on power, but we're kind of in a stalemate here because, until you get a lawyer, you still can file paperwork and you can defend yourself. So what I would do is I would object to this and try to get the order reversed. Because there's probably been no showing that you're not competent. And I would file the motion while I still could, I'd file the motion to dismiss and my own discovery request so that I could get that damn body cam footage that they'd, give it to me directly.
Okay.
So that would be my next move.
Fabulous. Okay. So, file a motion and to dismiss and file a motion for discovery. And what was that first thing? Order refused. Oh yeah, have the order reversed. I should have been a doctor. I write like heck. All right. Hey, I will let you get on to the next. I could talk to you all day. Marc Stevens, I love you. Have a good show. I'm going to listen to the rest of it.
I appreciate the call. Thank you. And hopefully this will turn around. So what the hell? I go, all right, well, guys, call back. 218-632-9399 is the caller number, and the passcode is 2020. So, all right, well, until we get them back, I will address something I want to address here that, I don't expect that everyone's listening to every single show. I get that. But there are certain things that I have repeated on the show, and it's almost a part of at least every other show when I talk about certain things. And it's coming up, recently. I'm actually going to spend some time on Tuesday to address some of Juan Galt's arguments again. We're not I should have just before getting this set up, like, is there any new argument, or are we just going to rehash the same thing that we did a number of years ago? I spoke to him for an hour and a half. Well, he spoke over me for an hour and a half. And I addressed all those issues. I've done other videos. I've done articles about it. I've talked about it endlessly on the show. And recently, so I'm going to do it again on Discord on Tuesday afternoon, and I'll record from my end. That's one thing I can get right. But somebody is saying here, Coplock Hot Springs, Marc will be defending against Juan Galt. No discussion of facts or evidence will take place. Complete waste of time. Galt will remain unmoved. Marc will remain unmoved. I don't get that. That's not me. I'll discuss the facts. What he wants to discuss is that he believes, and it's mimicked here. At least not today. So, hey, not today. So we got that. That's a bonus. So we may have started out with a tech issue, but we don't have a resident critic here with the same recycled arguments from Juan Galt. And that is that whether the Constitution, which is law, applies is a political issue. Now, it doesn't start out, and I've discussed this till I'm blue in the face, sometimes red. So, but I go through, detail. If I'm taking a position, I lay out my facts, I lay out my argument, and then that leads naturally to the conclusion. Now, that doesn't mean that someone like Juan Galt is going to accept that. And it doesn't mean that the two of us are going to have any kind of agreement. There's very, very little that guy, Juan Galt, and I agree on. So we'll see what happens, but it's certainly not going to be, if both sides are unmoved, it's not going to be because I did not present a good, lucid argument and I didn't do it based on the facts. So that Coplock Hot Springs, yeah, you're wrong on there. He may not present any evidence. He may just have the same, tired old argument, but that's not what I present. Someone saying, Marc, the repetition. Yeah, well, yeah, the repetition is fine because, not everyone's listening to every single show. You damn well should be, though. You should be. But I understand. I get it. So we'll see what happens. And, one of the things that obviously should and has to be discussed, if you're going to be discussing the fairness of a system, you cannot look at that just in a vacuum. And that's why I've done in videos where this, I kind of preface it with, if we're going to be talking about government, whether government courts are fair or not, our yardstick cannot be the rules of the organization only. Yeah, they may be helpful if they're consistent with basic principles of right and wrong. But like I use so many times, you do not judge the mafia based on the mafia's rules. So we're not going to judge government actions and when we're defending ourselves and whether we have a fair hearing or not, we're not going to use just that organization's rules. And you have to decide, is it a legitimate organization? Yes or no. Oh, here we go. I guess I spoke too soon. I guess I spoke too soon. Luther versus Borden, 48 U.S. 7 Howard, page 1, says it's a political issue. Yeah, okay. The Supreme Court also said back in 1849 that slavery was a good institution too. So things changed since 1849. So, but I'll get into that. I'm not going to waste any more time here. I'm going to waste time going through the same routine with Juan Galt on Tuesday, because I prefer to do it, in real time. And I don't like using text like that, because then you get accused of not being responsive, not addressed any actual argument. And so that's why I can go through in a 20-minute video and address line by line by line exhaustively, every single line, and still get accused of not addressing the argument. So that's why I'm not going to spend any more time there. Al is saying court citations are complete twaddle and poppycock. No, I'm not going to rebut everything on the show today. I just said, see, this is the thing with you damn critics. I just said I'm going to address it in detail on my call with Juan Galt. I'm so sick of this. Good Lord, childish. No matter what you say, that's what you get from some of these YouTube comments. I can just say again, I'm going to address it all in detail on my call with Juan Galt. That's a rebuttal? Oh my gosh. I'll do it all on Tuesday in real time with Juan Galt. So, oy vey. So, looks like we have a new caller. We got area code 140 or 401, 407. You're live on the No State Project.
There you go.
There we go. What's your name? Where are you calling from?
Got it. 407. Patriot One.
Oh, Patriot One.
Hey, I wanted to ask. I just got 3 letters from my sweetheart IRS.
Oh no.
This is not so bad. Telling me that for the years 2009, 15, and 16, that they're sending whatever they claim to a collection agency. And I was just wondering if you had any experience with that.
The IRS is sending you to a collection agency?
Yeah, it says current law requires us to contract with qualified collection agencies to assist collecting certain overdue federal taxes. We have assigned your account to the following agency, CBE Group. And that's all it says. It doesn't say what they claim I owe or anything. There's no other information except they're sending you to collection agency.
I don't remember seeing the IRS do that before. This may be a scam. I mean, do they have correct information on it, like a Social Security?
It's on the official IRS letterhead I've gotten for the past since '95, I think. But yeah, I was just wondering if you. I look at it as they've determined. In 2018, I filed the way I normally do. I corrected the W-2s, and they sent me a letter saying that we're going to apply your refund to 2009 debt. I wrote them back saying I object to your offer. I'm paraphrasing. Or I do not accept your terms and conditions. Please process my return for overpayment as filed under oath. Then I got a letter back saying you no longer need to do anything. And then I got 3 letters on the same day that they're sending to a collection agency. So I was just wondering if you ever seen that.
I don't remember seeing it from the IRS. At least no one that I've worked with. Maybe I'm just not remembering it, but it doesn't seem to ring a bell. It doesn't, I mean, I've seen state agencies do that. Like say, for example, somebody I know is getting hit with this, where let's say a student loan. So they'll get a collection agency after you offer a student loan, for example. But for an alleged IRS assessment that wasn't paid for a collection agency, yeah, I either I'm not remembering it or I'm just not familiar with it. I've not heard that.
Well, do you have a template for a debt collection notice type of thing?
Yeah, well, I'll tell you what I do. I'll mention again. It's probably been a while since this has come up. This works really well for especially outside of Arizona, because Arizona is the only one that does not have an actual statute making it a misdemeanor to practice law without a license. It's a contempt of court, but everywhere else it's a misdemeanor. So what I usually do is address at least, if it looks legit. Here, I think there may be a question whether it's actually, legit. But I respond back, it's with an abundance of caution that I contact you at all, because I'm not a lawyer and I'm not really good with all this legal stuff. That's probably going to be a clip that's going to be taken out of context too. Someone here, Mark Stevens admits he doesn't know anything about law. let's give them the sound clip right now. I don't know anything about law. And then that'll be up on somebody's website. So getting back, before I can respond, I need to know some more information. And are you asking me to give you an opinion on your client's legal rights? Because what they're giving you is a 30-day letter that you're supposed to respond to within 30 days, or whether you admit or deny the validity of the alleged debt. And in my twisted mind, I see that. And I've had debt collectors actually go, well, that sounds about right. If you're asking me if the debt is valid, I don't see how I'm not giving an opinion on the IRS's legal rights. I mean, does that make sense to you?
Well, it sort of does. My question would be to them, can you validate this debt? Do you have any facts or evidence proving this is wouldn't they need a court order to actually have a debt to collect?
No, they get a lien and it's considered due and payable on the day that the assessment is done, and that's why it's a lien that's in the ether. That's why the IRS only needs to file a notice of lien, because the lien is created in law. I know it's all made up, but the lien is created the day the assessment is done. I don't want to ask them for that. I would, because I'm dealing with a collection agency. What I want to just ask them is, are you asking me to give you an opinion on your client's legal rights? So I have technically responded, but I'm not responsive, but I'm trying to get more information because it is a legal process and I don't want to make a mistake. So that's why I asked that question. And I went through this with a debt collector who was collecting for the Mesa City Court, and they wound up tabling or killing the account. And so we're not even going to contact the court, but this is really interesting. So because they asked, what, and I have to tell them, they ask, well, why are you even asking this? Well, I'm asking because you could be entrapping me into committing a crime. I'm like, no, we're not. I was like, well, who's your boss? Who are you collecting for? Oh, I don't want you reporting back to the city court that I'm giving legal opinions, that's defined as the practice of law. So that's the way I would initially handle it. Have you gotten a 30-day letter from the collection agency, or is it just from the IRS at this point?
It's just all I got right now is this letter from the IRS saying they're sending it to the collection agency.
Okay,
and, I've heard people where collection agencies keep calling them and harassing them, and they're filing claims against the collection agency, getting rewards and things.
Well, that may or may not be true. It depends on how many times they're calling you. There are certain regulations or whatnot about how often they can contact you. But I would handle it if I get the 30 first, since they're not sending a 30-day letter yet. I would first investigate this and see. You could just do a search of do you have the company's name that's doing the alleged debt collection?
Oh yeah, I looked them up on the internet. CDB group, CB something group.
CBD group.
CBE group, Waterloo, Iowa. C is in captain, B is in boy, E is in Europe.
Or Echo.
Charlie Beta.
All right. Are they a debt collection company?
Yeah. Well,
all right. Well, it might be legitimate.
But I haven't heard from the collection company yet.
Well, if you do, that's how if I was to get, that's how I've taken care of all the debt collection notices that I get that way. That's how I at least start it. And yes, they will continue sending you the same 30-day letter a few times.
Well, like I said, I didn't get a 30-day letter. It doesn't say you have.
Well, I'm just saying that's how the process.
Say I have to do anything.
That's how right. But I'm saying if you do get the 30-day letter and you do it that way, in my experience, they just keep sending the same letter, and that's why they'll sometimes they'll do a skip trace, or they'll somehow find out your number, or you can just call them. But I had them do a skip trace, I guess.
When when I get like a 30-day letter or a notice from the IRS, I just simply reply back, I do not accept the terms and conditions of your offer. Please process my return for overpayment as filed under penalties of perjury. And I leave it at that. I just keep it nice and simple. And then they come back with a new thing. Sometimes it takes 6 months, sometimes a year and a half. Like I got here in 2009. I mean, come on, guys. How long?
Well, they have, they can just, there is a statute of limitations, but they can just allege fraud, and we just found out about it, and magically, there's no more statute of limitations. I would not be putting in there not accepting the offer, because that's a red flag that makes you look like a sovereign citizen type. So they're not extending an offer to you.
Well, I believe they are. I filed my return. They write me back saying, well, here's what we're going to do with it. And I say, no, I filed my return. Deal with my return. I don't accept your terms and conditions.
That's
I've
different than,
terms and conditions.
You're talking about people who are doing things without consent. And because there's no consent and they're using a force continuum, I don't see it as a legitimate offer. I mean, is it an offer for me to say, do you want me to break your arm or break your leg?
Well, that's what they're offering me,
But that's a threat.
Sorry,
that's not an offer.
Accept those term 60.
That's a threat, not an offer. Maybe in my non-lawyer mind that makes, it just makes sense to me, because I'm not a lawyer and I've never claimed to be one. But to me, saying, do I break when you don't have a choice, it doesn't sound like an offer. It's more of a veiled threat. So here it's just more of a veiled threat than necessarily an overt threat. Like when they come and say a notice of levy, that's an overt threat. This one is a little less obvious.
Well, they usually do have a sentence in there that says, if you disagree with our conclusions or something to that effect, call this number. I keep it all in writing. I've never given them my phone number. So
okay. Well, I like to call them up and start a dialogue with them and start asking for the facts. And then I'm recording, and then I write down everything, and then I use that against them if they're going to escalate the matter. And what you want to do is you're asking for the facts their opinions or claims are based on. And when they play the State Department two-step and want to push it to another department, then you ask for a stay of proceedings so that while they're getting to the right department, it doesn't escalate. That's the way I do it. And I always ask, and you get your statutory violation. You ask for an agent to be assigned with direct contact information. 3705 of the Restructuring and Reform Act of 1998 obligates them upon request. They have to do that. I know they have a policy for not doing it, but like I said, I'm trying to get something that one of these people will take notice of, and that, they go, well, where's your statutory violation, Mark? 3705 of the Restructuring Act. They have a policy not to comply with it. So that's how I do it.
I did one time. I wrote back at one agent, and I asked her, when you use the terms we, us, and our, actually, what do those terms mean? And I got a letter back from her. When I use the terms we, us, and our, I mean me. And I never heard from her again.
Oh, I'm glad for that. But that's how I would deal with it. I got to get. Oh, well, I'm at the end of the hour, so I do have some appointments after this. But that's how, let me know if you do get that 30-day letter. But what I would do is I would initially call the IRS. Usually best day is on a Tuesday morning. And just see what facts they have to support their claim that just because you made money in this part of North America, that the Constitution and laws apply and create this alleged obligation.
I'll do that. Thank you, Mark.
Appreciate the call. Patriot 1 out there. I'm going to drop off the caller line because One, I tentatively titled the show, Trump now has one more thing in common with Bill Clinton. So it's not just that they were friends with Jeffrey Epstein, but now, like Bill Clinton, he's getting impeached. It didn't happen with Nixon. He resigned before the House Judiciary Committee accepted voted on and accepted the articles of impeachment. Bill Clinton was impeached there, and so is Donald Trump. So now they got something. So they're both vile human beings. They're both presidents, so-called. They're both really good friends with Jeffrey Epstein, who didn't kill himself, and they've both been impeached. So, but the idea of these people crying foul, either side, it's so much more blatant with so-called Republicans. Here you've got people in Congress crying violation of due process. Wow. But I'm not gonna belabor the point anymore. I know that kind of stuff doesn't go over too well here on the show, but we did cover a lot of ground here. And like I always say, dissent is welcome. I know I'm gonna I did put the critic into timeout because I want to see stupid comments that don't add anything to the dialogue. That, just like lying. Marc has never gotten any of the motions granted. He's had no success in court. That's not a criticism. That's just a flat out lie. If you're going, it's not the same thing. And just stupid comments. I get enough of this crap during the week. And, if you want to have an intelligent dialogue, I'm okay. Yeah, I've got plenty of, evidence to that. Just like saying, but when you lie and you say, I've never had any success, and I've repeatedly brought out the evidence. I have a whole section on my website where I have documented proof. Oh, yeah. Oh, no, the judge was angry. I have a motion that for example, I like to bring this one out because I didn't have to redact it in Wisconsin, where the judge ordered the prosecution to respond to the motion to dismiss, ordered him to do that. And then the prosecutor comes back and says the same thing the critics all, say. It's frivolous. It has no merit whatsoever. All the critics believe that that's true, that it's legalistic gibberish. The judge issues an order and actually explains why he's granting the motion, that the prosecutor failed to provide the evidence or a legal reason why they weren't required to provide the evidence. The evidence in the motion that was missing. And what do you hear? Instead, there is no chance in the world. There is zero chance that the judge actually was being truthful when he granted the motion. Nope. He simply was pissed off at the prosecutor. And because I am such an idiot, and because I have not a career prosecutor, I couldn't possibly understand. So ignore the evidence and assume something. So when you have solid evidence, it doesn't matter, because they're pushing this thing that I'm a con man. I've never had any success. And even when so that's why they have to do, nope. The prosecutor pissed off the judge. That's their argument. The prosecutor pissed off the judge. And I've addressed this again, trying to show that it's just ignoring the evidence. Why would a judge order the prosecution to respond to a motion that is legalistic gibberish? The judge on his own motion can just deny the motion. Sua sponte, right? Sua sponte. The judge doesn't need a response from the prosecutor to deny a motion. It doesn't. They can do it on their own because they're determining that this motion has no legal merit whatsoever. And that has happened. Why would this judge, if the motion is so glaringly obvious that even a court reporter can determine it has no merit, but a sitting Superior Court judge, a sitting county judge, is not as smart as a court reporter. I am ordering you to respond to Marc Stevens' motion. See, any excuse. That's why I don't want to keep listening to the same lie. I don't want to listen to the same arguments, but I'm going to go ahead and I'm going to address it yet again. At least Juan Galt will talk to me instead of hiding behind a computer. You got to give him that. He'll at least discuss things in real time. I can imagine how I'm not going to spend any more time on that. It's just not worth the time. But it's interesting to see how things are playing out. How people who couldn't give a damn about due process are now screaming about it. The guy who said, "Take the guns, due process later." That same guy is now pissing and complaining. He's wetting himself, crying about due process violations. That is take the guns first. Could you imagine how that same guy and that these same damn politicians would be losing their minds if Barack Obama had actually said, take the guns, due process later? Oh, how they could actually and not see the hypocrisy. I think that they do see the hypocrisy. They just don't care because it's their guy. Congress, politicians crying about due process. Politicians. Yeah, I guess that's the old irony of the week. Someone's saying here, Trump talks crap just to trigger people. That's just the way he is. He said, that's kind of the excuse. Well, he was kidding. You can't take what he says serious. He's just kidding. He's kidding. See, that's the whole prank thing. Dude, it was a prank. It was just a prank, dude. Come on, bro. It's just a prank. No, you're a douche. That was hurtful. Whatever it happened to be. It's a joke. So, when we go to these courts, like Linda said, in Oklahoma, it's frightful, the things that go on. Yeah. It's also, taken into account that there are people who defend it every day. They see nothing wrong, and they make arguments. The same, the same arguments. Never coming up with a fresh argument on their own. Which is why I'm just going to address it with Juan and not have to do it with Juan's alter ego over here. The same argument every week, nonstop. Anyway, I'm glad we were able to get through the show without any additional tech issues. And if you'd like to help support the show, it is appreciated. It's markstevens.cells.com and markstevens.net, where you can get government indicted also. And if you're being attacked by a bureaucrat, I do have the templates that I mentioned and the scripts that I talk about on the show are at the website for you to purchase. And I will be live on Wednesday. So whoever I may have missed or you weren't able to get in today, I will be live Wednesday. And maybe we'll have some highlights about what, and I'll post. I'll more than likely post if it's just a complete retread. I don't know. If we're going to cover the same ground like we did last time, I don't know if I'll post something like that. But we'll see. But I am going to be having another discussion with Juan Galt on Tuesday. And I'm going to be covering the stuff that I didn't necessarily. The reason, and because of that, that's why I'm not going to cover all that on this show. I'm doing it on Tuesday. So we'll see what happens. Hopefully we've got some new material and it's not the same tired argument, but we'll see. But I will be live on Wednesday nonetheless. So, hey, till then, salud.